In this lecture, we'll be looking at Chapter 4 of our textbook, looking at civil liberties. And as always, the chapter starts out with a little, story kind of talking about what this has to do, how it can involve us in our lives. And so what we're going to look at in the question of civil liberties is we're looking at questions about the nature of freedoms found in the Constitution. First, we have our opening story of looking at free speech under the First Amendment. Here we had the public high school student who posted on Snapchat with an obscene gesture and the quote, F school, F softball, F cheer, F everybody. But obviously she didn't use F, she used the entire word. The school saw it and suspended her from the cheerleading team. And then her parents sued. Now we have to remember this was in a public school. And the Supreme Court in 2021 ruled in Brandy, the student's favor. They said Snapchat did not meet the court's disruptive standard because she spoke outside of school on her own time, she used her own cell phone, and did not target particular members of the school community with abusive language. The majority members on the court said that off-campus social media speech differs in three ways. First, parents, not the school, should regulate off-campus speech. Second, schools cannot and should not regulate student speech 24/7. And third, schools should protect even unpopular speech because America's public schools are the nurseries of democracy. And so what we're going to be looking at in this chapter is we're going to be looking at to what extent can and should the government restrict civil liberties. So let's first start by looking at what are civil liberties and how are they different from civil rights, which we'll be discussing civil rights in the next chapter, in Chapter 5. Now, these are very similar ideas. In fact, personally, when I was in law school, I took a class that was called Civil Rights, Civil Liberties. But here, the differences are civil liberties are areas of personal freedom constitutionally protected from government interference. So it means these are freedoms that we have because of the Constitution, and they are protected from government interference. Basically means there's protection from improper government action. They determine what the government may or may not do to restrict our individual freedoms. Then we have civil rights. Civil rights are guarantees of equal opportunity and protection through obligations imposed on the government to protect individuals. So civil rights, we're looking at what governments must do to ensure all citizens are treated equally, and that government should protect certain groups. So that's the difference between the two. Civil liberties, personal freedoms constitutionally protected from government interference. Civil rights, what governments must do to ensure all citizens are treated equally. The foundations of both of these are found in both federal and state constitutions. Also, what's interesting enough, as we discussed before, the Federalists did not think a Bill of Rights was needed because they believed the federal government was only given the powers delegated to it. We discussed this last chapter. And they claimed that the amendments in the Bill of Rights were already included in this. However, an example of this would be the idea of habeas corpus, which is an individual in custody must be brought to a court and shown the case for detention. They must also have an open trial with a judge. However, the Anti-Federalists insisted on the inclusion of the Bill of Rights. Basically, the Federalists agreed to add it as the first 10 amendments to gain the support of the Anti-Federalists. Okay. And now what we're going to see is the Constitution applied to the federal government. However, what we're going to see is then a lot of these powers eventually are going to also be meant to apply to the state. So we have the First Amendment. The First Amendment provides that, quote, Congress shall make no laws, unquote. This is the only one that addresses itself exclusively to the national government. So the question was, do the provisions of the Bill of Rights put limits only on the national government? Well, in 1833, the Supreme Court ruled yes, that it only applied to the national government. However, in 1868, with the ratification of the 14th Amendment, states no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the law. So now with the 14th Amendment, that sounds like it should now apply also to the states. However, for nearly 100 years, the court did not interpret it as such, except in the case of prohibiting states from taking property for public use without just compensation. And they did this using the 14th Amendment's Due Process Clause. However, in 1925, we're going to see this begin to change. In 1925, the court held that freedom of speech is among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. So no longer just the federal government, but the states also. In the 1960s, we have what's called selective incorporation, and this was where it was decided that each provision of the Bill of Rights was to be considered separately as a possible limit on states through the 14th Amendment. Now, only the 3rd and the 7th Amendments remain unincorporated. With that, almost all states voluntarily comply with the 7th Amendment. That's the right to trial by jury. And the 3rd Amendment is the quartering of soldiers in private homes hasn't actually really been an issue. Now, states do retain some ability to restrict individual freedoms. We can think of something in our recent lives with the COVID epidemic. State governments can require masking and vaccinations. They can do this under their policing powers, meaning taking an emergency action. Now, for the federal government, they could require it of their employees, but not the members of the general public. So that's why certain states were able to have vaccine and masking mandates, yet the federal government could not require this. All right, so now what we're going to spend the rest of the chapter looking at is looking at specific amendments and how our civil liberties apply. So we're going to start and spend the most time with the First Amendment. So the First Amendment guarantees the freedom of religion in 2 distinct clauses. We have what's called the Establishment Clause. This is where it states, Congress shall make no law respecting an establishment of religion, meaning the government cannot create a national religion. Then we have what's also called the Free Exercise Clause, meaning that they cannot prohibit the free exercise of religion, which also includes non-belief. So because of this, this establishes what we often consider a separation between church and state. Under the Establishment Clause, this means there is a wall of separation between the church and the state. The government cannot establish an official religion, but may provide assistance to religions or institutions or ideas as long as it does not take sides or show favoritism among them. And courts have often upheld these relations. Example of this could be, showing Christmas displays. Well, if you allow a Christmas display, in front of on public property, then you also have to allow all the other religions to have their displays. This wall of separation was actually Jefferson's formulation, but there have been often conflicts over how high this wall of separation should be. Example of this would be in public education. Here, courts have struck down Bible reading, prayer, meditation, and prayer at sporting events because these organized religious activities strongly suggest the schools are sponsoring them, and that's not allowed under the First Amendment. All right, then we also have the Free Exercise Clause. Again, this protects citizens' right to believe and practice whatever religion they choose, including non-belief. And we see this in West Virginia State Board of Education versus Barnett from 1943. This was a Supreme Court case, and here the court stated the school could not force a child who was a Jehovah's Witness to salute and pledge allegiance to the American flag. We also see this being discussed in Burnwell versus Hobby Lobby stores from 2014. This is where there was a section of the Affordable Care Act that required employees to provide their female employees with free contraceptive coverage. However, Hobby Lobby's owners said this violates their religious beliefs. There was the Religious Freedom Restoration Act of 1993, and this required the government to prove, quote, a compelling interest, unquote, for requiring individuals to obey a law that violates their religious beliefs. So in this court case, the Supreme Court ruled in favor of Hobby Lobby. They said under the Religious Freedom Restoration Act that the government could not show, right, a compelling interest for requiring Hobby Lobby to provide contraceptive coverage for their female employees. Also under the First Amendment, we have freedom of speech and press. The idea behind this is that democracy depends on the ability of individuals to talk to one another and to disseminate this information. This is seen as an essential way to evaluate competing ideas. And any time when we see our government trying to restrict our freedoms of speech, we should definitely be suspect and aware. In 1938, the Supreme Court held that any legislation restricting speech is to be subjected to a more exacting judicial scrutiny. And this is what's called strict scrutiny, meaning a higher level of review. So basically what this means is that any speech that is restricted is automatically suspect, that the government must show a compelling reason to prevent such speech. An example of this is you're not allowed to yell fire in a crowded movie theater if there's not a fire. The courts have held that's not restricting free speech. Why? The compelling government interest here, right? If you yell fire and there's not a fire, it's the health and safety and welfare of everybody else in the movie theater. When we think about speech, all speech is protected, but some forms are entitled to greater degrees of protection. So now what we're going to look at is we're going to look at some different types of speech. And we're going to start with political speech. Speech can be limited if it presents a clear and present danger. This was actually the first test to see when government can limit speech. And what's interesting is why they said they can limit it if there is a clear and present danger. However, now this has largely been discarded. Political speech has largely been protected by the courts, even when the speech is considered insulting and outrageous. It has also been used to allow large contributions from wealthy donors to political campaigns. And they're saying they allow this because it's part of these wealthy donors, it's part of their protected First Amendment rights under political speech. All right, next we have what's called fighting words and hate speech. This is expressive speech that directly incites physical conflict. That's a definition of fighting words. In 1942, the Supreme Court said they are no part of the exposition of ideas, so they are not allowed. So free fighting word speech is not allowed. In 1951, they held there is no substantial public interest in permitting certain types of speech, including fighting words. However, since that time, though, the court has overturned almost every conviction based on fighting words. And then we have hate speech. Hate speech is forms of expression intended to assert hatred toward one or another group of people. The Constitution does protect the rights of individuals to share controversial views. However, the conflict arises when that right comes up against a university's policies to emphasize safety, is an example of that. So it's this balancing. We have the protection, right, to share controversial views, but how far does that protection go? And your example from the textbook was allowing this speech on the public properties. Yet what happens when we have this speech that's going to incite possible violence? And then that's then going to go against the university's policies to emphasize safety. So we'll see that in individual aspects. Also, what we now see in the modern age is social media platforms. These are largely not federally regulated right now. In 2019, Facebook did adjust their terms to not allow hateful posts and claims. However, we have to remember that was Facebook doing it. Facebook is a private company. And so the restrictions on the government actions do not apply. Because again, it was Facebook doing it for its own terms. So if you didn't like the terms that Facebook put out there, You just don't use Facebook. All right, next we're going to look at student speech, and this is student speech in public schools. Again, this is how we started out our chapter. So with student speech, there are actually a few types of speech that have limited protection, and this is one. Courts have held that speech that interfered with the school's goal of teaching students the limits of socially accepted behavior is not allowed. Yet something I want you to think about is who sets this standard of what is socially accepted behavior. The courts have also held that speech and journalism in schools as part of their education are not protected with the same standard as adult speech in the public forum, meaning they're saying it's part of the it's part of the education, therefore it's not the same as the New York Times publishing a story. However, as the chapter started, the court has held the school cannot regulate student speech off of campus. Now again, this is public schools. Private schools are different. Their rules apply because they are private. Again, if you don't like it, you don't go to the private school. All right, next we have what's called commercial speech. This is looking at newspapers or television advertisements. At first, they were seen as entirely outside the First Amendment protections. The Federal Trade Commission prohibits false and misleading advertising, and the court has actually upheld the ban on posting commercial signs on publicly owned property as long as there is a total ban and no hint of selective censorship. More recently, commercial speech has become more protected. In 1975, the court struck down a state law prohibiting the circulation of newspapers and magazines encouraging abortions. The Supreme Court said this infringed on both constitutionally protected speech and the reader's right to make informed choices. Next, we have symbolic speech. So what's symbolic speech? This is peaceful actions designed to send a political message. An example of this would be the burning of the U.S. flag. Courts have largely upheld this action. And this is also what's called speech plus, meaning we're combining speech with physical activities such as picketing, demonstration, or assembly. And we see this in the Supreme Court case of Hague versus the Committee for Industrial Organization in 1939. Here, the court held the government could not prohibit speech-related activities such as demonstrations and leafletting in public areas traditionally used for that purpose. Now, the state could impose rules to protect the public safety at such events as long as they do not discriminate against a particular viewpoint. So say we have two sides who are, debating over a specific topic. The state couldn't say, well, so there's not a conflict, we'll only allow one side there or not the other. That would not be allowed because that would be discriminating against a particular viewpoint. All right, this is going to lead us to another First Amendment freedom, which is the freedom of association. Again, here, this is also protected by the First Amendment. And what the freedom of association is, it allows groups to organize and advocate for their beliefs. And then that's going to bring us to freedom of the press. Now, our textbook talks about what's called prior restraint. Prior restraint is an effort by a governmental agency to block the publication of material it deems liable or harmful in some other way. Now, the courts, though, have ruled against this, except for broadcast media, which is regulated by the federal government. The court has held that except under the most extraordinary circumstances, the First Amendment prohibits government agencies from preventing newspapers or magazines from publishing basically whatever they wish. And we saw this established in the 1931 Supreme Court case of Neer v. Minnesota. We also have the Supreme Court case of the New York Times Company versus the United States from 1971. Here, the court held the government could not block the publication of the Pentagon Papers, which were secret Defense Department documents that had been provided to the New York Times. Now, these had been provided to the New York Times by an opponent of the Vietnam War who got them illegally. However, they said the New York Times still had the right to publish these. There's also the question of, can journalists be compelled to reveal the sources? Now, most dramas like to tell us no, they can't. However, we do have about 40 states that have what's called shield laws, where journalists are allowed to protect their sources. However, there is actually no federal shield law and no special constitutional protection for journalists. All right, that's also going to bring us to under freedom of the press, looking at libel and slander. And this is again where we're looking at some speech that is not protected. And libel and slander are examples of that. So what is libel? Libel is a written statement made in reckless disregard of the truth that is considered damaging to a victim because it is malicious, scandalous, and defamatory. Slander is the same thing, but that is a statement that's only made orally. However, with both libel and slander, it's actually very hard to prove this for both politicians and other public figures. It's hard for them to win these cases, number one, because of the nature of their job, and not only does the statement have to be untrue, but it also had to result from actual malice or reckless disregard for the truth. Basically, the newspaper had to print false and damaging material deliberately. And also, it's very hard to prove actual damages in this, right? Just claiming, well, my reputation was damaged. Well, what actual damages are those? The court can't say, oh, no, your reputation is fine. So it's very hard to prove damages in these cases. And that finally brings us under the First Amendment to obscenity and pornography. Now, these are even trickier. In 1957, the court held the standard for obscenity to be speech or writing that appeals to the prurient interest. What is the prurient interest? The prurient interest is the purpose of the speech is to excite lust as this appeals to the average person applying contemporary community standards. Well, what does that mean, right? And even if it does apply, the work should be judged obscene only when it is utterly without redeeming social importance. So what does that mean? It was a very unclear standard. And in 1964, Justice Potter Stewart famously confessed that he found pornography impossible to find, but he stated, quote, "I know it when I see it," unquote. Think, is this the standard we really want for protection of our free speech? Now, relatively recently, this issue is dealing more with online pornography. And largely, this is still relatively unrestricted, except in cases of child pornography. Also, we look at this, cable television, not broadcast, also has protections and also relate to the idea of publications of things considered excessively violent. Generally, in these cases, the courts uphold the freedom of speech. All right, now we're going to start looking at some of the other amendments. So that brings us second to the Second Amendment, which is largely looked at as the right to bear arms. And with the Second Amendment, there's a debate over what it means. So you can read the full amendment. And part of the question is, well, what was the purpose of the Second Amendment? Some say the purpose was to have a militia. Well, what was the militia? A military or police resource of the state. Largely, we do not have those now. The other debate is, well, does it include an individual's right to bear arms? Now, many localities and states have very different laws concerning gun ownership, and you can see this in Figure 4.1 in your textbook. In 2008, the Supreme Court expanded gun-owning rights, and we see this first in the court case of Columbia versus Heller in 2008. Here, the court struck down a Washington, D.C. law that banned handguns. The court ruled the Second Amendment provides a constitutional right to keep a loaded handgun at home for self-defense. They stated this was not intended, though, to stop laws prohibiting ex-felons and the mentally unstable to possess firearms. Now, we also have to remember this was in the District of Columbia, which is a federal entity, so this did not apply to the states. However, in McDonald v. Chicago in 2010, the court did apply this standard to the states. We also saw in 2022, the court struck down a New York state statute requiring a person to show a special need for self-protection to receive an unrestricted license to carry a concealed fire alarm outside the home. The court said no, this was too much of a restriction on an individual's civil liberties. As we see and we know today, this remains a largely contested issue in the United States, especially with how many mass shootings are going on. All right, next we're going to look at the rights of what are considered the criminally accused, and this includes the 4th, 5th, 6th, and 8th Amendments. And what we're looking at here, right, is we're looking at the due process of law. What's due process of law? It's the right of every individual against arbitrary action by national or state governments. So we're going to begin by looking at the 4th Amendment, which looks at searches and seizures. The purpose is to guarantee the security of citizens against unreasonable searches and seizures. We're going to see this mainly established by the court through Mapp v. Ohio from 1961. Here, this established the exclusionary rule, which is this prohibits evidence obtained during an illegal search from being introduced at a trial. So what happened is, based on a tip, police believed that Dolry Mapp was harboring a suspect in a bombing incident. So police officers came to his house and claimed they had a warrant and forcibly entered Mapp's house. They did not find the suspect, but they found an old trunk in the basement with materials they claimed to be obscene. Because of this, Mapp was convicted of possession of obscene materials. No warrant was ever produced in the case. Now, the Supreme Court in this case affirmed the exclusionary rule, stating that all evidence obtained by searches and seizures in violation of the Constitution is inadmissible. So since this was an unreasonable search and seizure, they could not use that evidence, the trunk full of obscene material, in the court case against Mapp. Because of this, he could no longer be convicted. In recent years, the court has softened the application of this some. Also, what's interesting is recent changes in technology have offered new challenges to this, such as tracking of cell phones, searching digital content, DNA evidence, and attaching GPS devices. So these are things that our court cases are now dealing with. All right, that's going to move us to the 5th Amendment. Under the 5th Amendment, first we're going to look at grand juries. Now, grand juries is considered the oldest institution known to the Constitution. And what they are is they're a jury made up of a body of citizens that determine whether there is sufficient evidence available to justify a trial. If a grand jury says, well, we don't think there's enough evidence to bring this to trial, the case is over. Now, this is, again, only federal. This does not apply to the states under the 14th Amendment, so not all states require a grand jury. Then we have what's called double jeopardy. This is protection that a person cannot be tried twice for the same crime. This does apply to the states via the court's ruling in Benton v. Maryland in 1969. And then this brings us to self-incrimination. This is self-incrimination is that no citizen shall be compelled in any criminal case to be a witness against himself. And we see this in Miranda v. Arizona from 1966. In this Supreme Court case, we had Ernesto Miranda, who was convicted and sentenced between 20 to 30 years for the kidnapping and rape of a woman in Arizona. The woman had identified him in a police lineup, and after 2 hours of questioning, Miranda confessed and signed a statement that his confession had been made voluntarily and without threats or promise of immunity. However, after his conviction, he argued that his confession was not truly voluntary and that he had not been informed of his right to remain silent or his right to consult an attorney. And the Supreme Court agreed this was a violation under the Fifth Amendment and overturned the conviction. So this produced the rules police must follow before questioning and arrest criminal suspect, and the reading of a person's Miranda rights, which you can see I have on the image on this slide. All right, next we're going to look at the Sixth Amendment, which is the right to counsel. Here we're going to look at Gideon v. Wainwright from 1963. Here, Gideon was found guilty for breaking into a pool room in Panama City, Florida. He received a sentence of 5 years in jail. Now, Florida at the time only provided a court-appointed attorney for crimes carrying the death penalty. So Gideon actually made his own appeal in a handwritten petition saying he was refused his right to counsel. And he won. And this established the right to counsel in all felony cases, not just crimes carrying the death penalty. Also, this includes the right to a speedy trial and the right to confront witnesses before an impartial jury. These are all also in the Sixth Amendment, but they're not very controversial. We really don't see them come up at all. And then this is going to take us to the Eighth Amendment, which is the cruel and unusual punishment. Really, the only debate over the Eighth Amendment is the last clause. What is considered cruel and unusual? Now, this has changed from culture to culture and generation to generation. Since 1976, the court has reaffirmed the death penalty could be used if certain standards were met. The court has also consistently upheld state laws providing for capital punishment. However, they also review death penalty appeals each year. Remember, the Supreme Court gets to choose what cases they hear. And this is a good thing, right? Why? Because we want the court to constantly be re-examining this. We can also see specific stats on states and numbers of executions in your textbook. However, the court has had long struggled to establish principles to govern executions under the Eighth Amendment. And again, this is a good thing. We want this to be something that the courts are constantly examining. Some examples of this is they've prohibited the death of a defendant with an IQ under 70 and also prohibited the execution of a very youthful defendant. Also under the Eighth Amendment, this prohibits excessive fines, and we see this in the 19 Timms versus Indiana, that this does also apply to the states. Now this is going to bring us to our last topic in the chapter, which is the right to privacy, or more aptly put, the right to be left alone. Now what's interesting is the right to privacy is actually nowhere within the Constitution nor the Bill of Rights. In 1928, Justice Louis Brandeis of the Supreme Court argued in a dissenting opinion, which is not the winning side. He stated the Fourth Amendment's provision for the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures should be extended to a more general principle of a right to privacy in the home. And we're going to look at how this right of privacy has been applied or not in some certain situations. This is not an exhaustive list. So first we have eminent domain, which we've already talked a little bit about. This is the right of the government to take private property for public use. What is private property? Property belonging to an individual for their own peaceful enjoyment. Now with this, the government does have the right to take public property for public use, and it needs to be, though, for the public at large. So an example of a public road that needs to be built or expanded. And so they balance those two rights, right? Which has the greater right? The private property or the needs of the public at large? The Fifth Amendment's taking clause requires the government to show a public purpose and provide fair payment for the taking of someone's private property. All right, then we have the topic of birth control. We largely see this in Griswold v. Connecticut from 1965. Here, the Supreme Court held a Connecticut law forbidding the use of contraceptives by married couples violated the marital right to privacy. They said this marital right to privacy is actually older than the Bill of Rights itself, and they also said it was grounded in the zones of privacy created by the Third, Fourth, and Fifth Amendments. Next, that brings us to abortion, something that we've actually seen change in the last few years. In 1973, in the Supreme Court case of Roe v. Wade, this extended the right to a woman's right to an abortion before the fetus became viable, which was about the 27th week. However, in Dobbs v. Jackson Women's Health Organization in 2022, this overturned Roe, stating the Constitution did not confer the right to an abortion. What happens with this? Does this mean abortions are now illegal? No, regulation of abortion goes back to the states. And you can see page 121 in your textbook for a map of access to abortion since the Dobbs ruling. And now that's going to bring us to sexual orientation. Sexual orientation is still not a fully constitutionally protected class. In Bowers v. Hardwick in 1986, the court stated there is no fundamental right upon homosexual sodomy. However, they also stated looking at the same-sex and heterosexual couples would be constitutional. And we have to remember when we look at sodomy, this includes oral sex. It actually wasn't until 2003 in Lawrence v. Texas that the court overturned the Hardwick decision. The court stated that gay people are entitled to respect for their private lives as a matter of constitutional due process, and that the state cannot demean their existence or control their destiny by making their private, consensual, adult sexual conduct a crime. At that time, several states, mostly in the South, still had these anti-sodomy laws on their books. In 2015, we see the Obergefell v. Hodges case, and this is where the court declared that state bans on same-sex marriage were unconstitutional because they violated the 14th Amendment's equal protection and due process clause. And then our final case is from 2020, and this is looking at Borstak versus Clayton County. Here, the court held an employer could not fire an individual based solely on their sexual orientation or transgender status. They held this was a violation of Title VII of the Civil Rights Act of 1964, which was meant to protect discrimination in the workplace. Now note, this was only that an employer could not fire an individual based solely on their sexual orientation or transgender status. This is a win for the LGBTQ plus community. However, they did not state anything about the other three protections in Title VII of the Civil Rights Act of 1964, which includes that an employee is not allowed to not hire somebody based on homosexuality or transgender status, nor if they can refuse to promote somebody because of this or demote somebody because of this. Now, your text claims that this opinion is a positive one. Why? Because it was written by one of the court's more conservative justices, Neil Gorsuch. And the text said that this implies an increased support to the LGBTQ individuals. And personally, I guess we will see. The current administration would suggest otherwise. However, public support is relatively still in favor of protections of LGBTQ plus rights, even though that number has actually been declining in the past few years. So we'll have to see what current courts rule on all of these topics.